Last week, the Delhi High Court passed an important judgment in Laksh Vir Singh Yadav versus Union of India. Justice Sachin Datta held that the right to privacy under Article 21 of the Indian Constitution extends to the right to be forgotten. The relief granted to the petitioners asked search engines like Google and service providers like Indian Kanoon to delist names from judgments and orders and to disable name based searches. The judgment aims to retain the public nature of the records and to discourage access to them through name based searches. Now, on the outset, this is a reasonable ask. The European equivalent of this is Article 17 of the General Data Protection Regulation, or GDPR as we say, under the right to erasure. The moral argument is quite simple and intuitive. Humans forget and machines do not. A person is entitled to some distance from their worst day. This is the right to be left alone, restated for a medium that has abolished the natural decay of memory. Nobody really needs to be reminded ad nauseum of an arrest that ended in an acquittal, or a complaint that ended in some closure report, or a marriage that ended in court. A person mentioned incidentally in litigation should not spend the rest of their life explaining that this case was never really about them. And the internet prevents this forgetting. On that normative question, the court's views echo common sense. They also acknowledge the importance of open justice. So, records are to remain open and searchable for public interest. So, for example, an offender against women or children gets no clean slate because the public interest in that information does not fade with time and exists to protect other people. Likewise, a person who is convicted of a breach of public trust, or an elected representative who faces heightened and continuous scrutiny under the logic of public accountability, these are not the scenarios that the court envisions this rule to apply on. So the court sorted cases by their public relevance so that a criminal conviction may legitimately surface on a name search, while a matrimonial dispute may not, and it allowed masking of private and sensitive matters in the application. The rule against de-indexing aims to deter only easy aggregation. However, it is really hard to take a right seriously that is granted but not guaranteed. After all, intent alone is wishful thinking if it's not aided by sensible policy that is cognizant of real world constraints. The process surrounding the right to be forgotten really needs to be practical and implementable. And the Delhi High Court judgment doesn't really deliver on this expectation. Let's start with the definition. Who is the forgetter? The judgment names Google and Indian Kanoon, and then it orders the Ministry of Electronics and Information Technology, or MeitY, to communicate directions to named parties and all other search engine operators and intermediary platforms operating within India. When MeitY files this compliance affidavit, which it's supposed to do in 4 weeks, will it really contain a list of all such providers, or will MeitY put out some instructions to the public at large? Because there's no stable, obvious universe of actors waiting to be notified. And the judgment really does not engage with the question of who is the forgetter. See, most people don't really consume a case by reading judgments or by searching across legal databases. They read news reports, there are tweet threads by Live Law and Bar and Bench, there are social media opinions formed by lawyers. And this is how people come across information. Google may have become a common noun today, but they're not the only search provider. The High Court judgment also recognizes that associated reportage to a court order may exist, but it doesn't list out what the expectation is from these entities. The court should really contend more deeply with Shakespeare's profound question, what's in a name? It assumes that there is a clear and identifiable party field in court data. Now, those who've wrestled with High Court and District Court orders recognize that most courts hydrate the case title with an and ORS, which stands for and others, making them of very limited use. Orders are poorly scanned, and they're often littered with misspellings and incoherence. Private search service providers clean up entities from court metadata and aggregate such information to make it searchable. Turning off party names is easy, but it's a cosmetic change. Even if names are de-indexed, what prevents a regular free text search from throwing up this information? It would still match on the order text, and it doesn't really solve for the problem that the court wants to address. Also, a regulation that can be evaded easily by anyone with enough resources should be honest about its limitations. I mean, we have a do not disturb registry, and despite being on it, most people still receive spam calls, peddling credit card, loans, health, wealth, and other shady things. It's just one example of a rule not being properly enforced. I'm sure you can find many others in India. Indian platforms with offices in the country who either fear being in contempt of the court or fear government action, they may comply. But the internet is global. Rules imposed by Indian courts cannot really bind actors sitting outside India's borders beyond a point. Moreover, most things on the internet have already been copied into some or the other database. Apart from legal databases like Manupatra and SEC Online, there are large language models that have already ingested huge volumes of public court records. Once a name sits inside a training corpus tokenized and stored in a vector database, de-indexing Google achieves very little. And even prospectively speaking, while this judgment may have made it hard to use code to aggregate appearances of a person's name, it's not really all that expensive to hire people to do such tasks manually. Uh, Finally, there is an odd gap between the court order and the source of the problem. For some reason, all the attention is on Indian Kanoon and Google, but they're merely republishing what the courts do. The Supreme Court's own case search system permits party name based searches, with the practical limitation that the search be year-wise, which isn't really all that much of a limitation. Even in a matter referenced in the judgment, the court notes that the identity of a victim of sexual offences was statutorily protected under Section 228 of the IBC and now 72 of the BNS. It then goes on to chastise Indian Kanoon, casting liability upon them to verify at the point of upload that no identifiers are present in the case orders. This censure should have been directed against the court's own registry, which published the record, rather than placing the onus on a private provider who's only republishing the record. The greater irony is that firms like Indian Kanoon and us to some extent exist because official alternatives are really poor. The e-courts portals, individual high court and tribunal sites, and various official government databases are slow and unreliable. They're riddled with idiosyncrasy. Case type abbreviations vary by registry, sessions expire, captchas interrupt access, the formats are inconsistent, and you can't really use them for machine readability. This is not to suggest that the Delhi High Court judgment isn't sound. Okay, after all, the consensus of whether society should have a right to be forgotten, is something that must come. That society must decide for itself. And perhaps the courts have identified a real harm and located it under Article 21 and refused to let the absence of a statute become an excuse for inaction. But a good diagnosis alone does not lend itself naturally to a workable cure. Without a coherent framework on data privacy and the date of expiry on public proceedings, we're left to debate the subjective. Is this a principle? Is this or a discretionary cleanup that is conducted once in a while on a case-by-case basis? After all, the court itself rejected some of the reliefs sought by some of the other petitioners in connected cases. The judgment has laid out an intent, but the execution of that intent requires greater scrutiny and detailing. This ideally requires legislation and clear rules on data fiduciaries and their responsibilities. Who is actually responsible for forgetting? Is it the court, the search engines, newspapers, databases, or large language models? Courts just need a better framework for managing legal information systems. De-indexing may have its place, but it's a rather simplistic understanding of information storage and retrieval. And good faith actors may comply, but the burden of forgetting cannot be on whoever it is easiest to find. Forgetting, like justice, has to begin at the source. And it can only work if someone is held responsible for remembering properly in the first place.